Sir John Whittingdale.
Thank you, Madam Deputy Speaker, and it's a pleasure to follow the Honourable Lady opposite, whose speech I thought was absolutely spot on. I agreed with it completely. It will not surprise the front bench on the other side that I welcome this bill. There are very few parts of it which I disagree with, if any, perhaps because it does bear an extraordinary similarity to the bill which was introduced under the last government and which I spent many happy hours taking through committee and then report stage of this House. As the Secretary of State pointed out, unfortunately it fell as a result of the calling of the general election, and I share his regret that it wasn't possible to get it onto the statute book. It is another reason, amongst many, why I regret the calling of the general election at the time which the last Prime Minister chose.
I note that he refers to all these happy days that he had, but I don't think he really enjoyed the report stage of the last bill, because I think he might... nobody else will notice if he admits here now that he didn't really like everything that was in the government's version of the last bill, and he rather prefers our version to their version.
Well, actually, the Honourable gentleman and I had a robust but nevertheless amicable exchange at report stage. It was, in fact, his colleague, the member for Barnsley South, who took it through committee, but it wasn't until report stage that the previous government decided to add to the bill measures which, of course, I fully supported, but nevertheless, it did make the task a little more difficult, since it resulted in there being a lack of agreement across the chamber, which had previously pertained throughout the entire passage of the bill. But nevertheless, it's a pleasure to be debating it again, and indeed to see not just the honourable gentleman, but indeed some of the officials who laboured to take it through committee when I was doing so, and who are now faced with having to do the same task all over again. As I say, the one point about the bill which the Secretary of State did not reference is a lot of the bill is to improve the working of data protection law in this country, to make data more accessible whilst at the same time safeguarding very important privacy rights. But the fact that we are able to make these changes and improve our data protection laws is a consequence of Britain's no longer being a member of the European Union. Otherwise, we were trapped by the GDPR requirements, and this is an example of where actually we can draft legislation which is to the benefit of people in this country and not have to accept a top-down imposed legislation from Brussels. That was another reason why I was an enthusiastic supporter of the bill. The one issue which featured during a lot of the debate previously, and I'm slightly surprised has not been mentioned so far, was whether or not the changes that were being made in the bill would in any way jeopardise data adequacy, the recognition by the EU. I'm sorry, the Honourable Lady did refer to it, but the Secretary of State did not. And it is a very important issue because there have been concerns expressed outside of this House that it might put at risk data adequacy. That was something which we were very keen to make sure was not the case. And we worked very closely, and I'm sure the Minister continues to work very closely with John Edwards, the Information Commissioner, who has a lot of experience in this field, having previously overseen the data protection regime in New Zealand, which again enjoys data adequacy but is not identical to GDPR. And I'm sure, given that the bill is so similar, that there is no risk to data adequacy, which I recognise is of importance to many large firms. And the bill also covers a lot of other areas which we regarded as important and which have remained largely unchanged. Things like the operation of the Information Commissioner's Office, digital identification, the National Underground Asset Register, the electronic use of the Register of Births and Marriages, the extension of smart data use, automated decision-making, and the retention of information where required by coroners after child deaths. All of those were in the previous bill, and I'm delighted to see that they're all still in this bill. And of course I give way to my honourable friend.
I'm grateful to my right honourable friend for giving way, and if I may take the opportunity to
explore some of his knowledge and expertise in this area. Would he like to comment on the balance in this bill between safeguards on the one hand and freedom on the other? I'd be interested in his thoughts on that.
I mean, if my honourable friend is referring particularly to data protection, it is a careful balance. People are rightly concerned that their data is protected and that they should have privacy rights, and there are campaigning organisations out there who have examined the bill and have expressed concern, and it was something that we were careful to ensure that the standards of data protection required are maintained, and I'm sure the government will take the same view. But at the same time, and this is one of the areas where there are small differences between the previous bill and the government's bill, we were very keen to ensure that data protection did not impose unnecessary burdens on particularly small businesses. And so there were one or two areas where we felt we were able to slightly relax the definitions and to reduce the burden on business, but the government has actually taken a different view. They are relatively minor, they are relatively technical, but things like the definition of vexatious and excessive, which was an issue which occupied a lot of discussion previously. The government has now removed that and reverted to the previous definition, which we felt was unnecessarily burdensome. And the whole area in which subject access requests could be made to firms and occupy a huge amount of time in trying to respond to them, we felt that there needed to be at least some safeguard to prevent those becoming, as we defined it, vexatious. And so I regret the fact that the government has not proceeded with that particular element. But it is relatively minor, and in the large part the bill is one which previously enjoyed cross-party consensus when it went through this chamber in the last Parliament, and I suspect will continue to enjoy cross-party consensus as it moves into committee in this stage. But I hasten to add, Secretary of State no longer with us, but I hasten to add that I'm not volunteering to serve on the Select Committee, on the Bill Committee, having endured many hours previously. I don't particularly want to repeat that experience. Inevitably, perhaps in part because the bill does enjoy a lot of support across the House, there are particular elements where there is real concern, and that relates to the area of copyright protection and artificial intelligence. It is worth saying that it was not originally in the bill at all, and I congratulate Baroness Kidron in the other place, who managed to persuade the clerks to allow her to move the amendments to insert it into the bill, and so it now is a part of the bill. And they are amendments which I think are very important and which I very much welcome. Now, the member for Bury South referred in his speech to the fact that the government hadn't acted in this area. And he's right. The Conservative government did not act because we felt and continue to feel that the law on copyright is clear and it does not need changing. What the government has done is proposed to change the law to bring in the text and data mining exception. And that is to create the opportunity for AI to take, to scrape and ingest creative content of the kind that the Honourable Lady, the member for Scarborough and Whitby was referring to, using an exception that the government is proposing to bring in. That is something which was proposed under the last government, but I can tell you that the last government rejected it precisely because we did feel that it would drive a coach and horses through copyright law and would do real damage to the creative industries. I'll give away to the Honourable Chairman.
I'm very grateful to the Honourable Gentleman for giving where his speech is very helpful. He's making some very useful contributions. The Shadow Minister wouldn't give us any clarity on his party's position on the opt-out mechanism earlier, so I wonder perhaps if he can help with that. What is his party's position on it? Do they support it or not? Yes or no?
I'm very happy to address it. I'm not a member of the front bench, but I will tell him my view, which is very clear. I have profound reservations about the opt-out. It reverses the whole principle of copyright law that the owners of rights have to go and say that they don't want to have their rights taken away. Otherwise, there is a right for people to do so. I would prefer to see an opting in, or in actual fact, a licensing method whereby rights holders could agree, if they wish to do so, that their content could be used. And I give way to the Honourable Gentleman.
To the Honourable Gentleman, if only he was on the Conservative front bench in issues such as this, I think we'd have a little bit of clarity. But he's absolutely spot on. There is no issue about copyright. There's no confusion about what's required in terms of the law. And all the government are doing is trying to create some sort of smokescreen so they could start to dismantle our copyright regime and water it down. What does the Honourable Gentleman think about those attempts? And will he join the rest of us in standing up for the copyright regime as it currently stands and there's no question about its legality?
Well, can I assure the Honourable Gentleman I have no wish to replace my honourable friend, the member for Havant, who is doing an excellent job. But nevertheless, he and I have been involved in discussions around copyright for many years, and of course I share his view. And indeed, I welcomed the debate that we had in this place just a couple of weeks ago on the creative industries, where a lot of these arguments were rehearsed. And the Minister very helpfully agreed that there is no workable opt-out technology available. The existing one, which the European Union had suggested, simply does not work. And on top of that, it is unenforceable. So the Minister and the Secretary of State have suggested that they would not proceed unless a workable opt-out could be developed. Well, it will be a first. In any case, as I say, I'm opposed to opt-out in principle, but it is also practically, at present, impossible to introduce. And I hear the Secretary of State talking about the technology companies working to bring it forward, a workable solution. But I hope that the Minister will again make clear that the government will not proceed unless there is a viable, workable technological solution which allows rights holders to make clear and have enforced that they do not wish to have their works used by artificial intelligence training models.
I thought it might just be easy to do that now. Yes, completely and utterly agree. That is our settled view. We do want to get to a process where there's more licensing of content. We've said that repeatedly. That's one of our aims of our consultation. I note that he says that copyright doesn't need changing. However, the amendments that Baroness Kidron tabled in the Lords do change copyright law. So I think we're going to have to square this circle at some point during the process of the bill.
Well, what I'd say to the Minister is I think what the amendments that Baroness Kidron tabled achieve is to put in very clear terms what we believe the law is already. And actually, there are a number of cases going through, and the Honourable Lady referred to the one in America, which was a very important judgment, saying that AI training did not constitute fair use. That was an American court, but previously we've been told that America was ahead in encouraging and promoting the use of this technology. So it is reassuring that even in America, they recognise the importance of protecting creative works. And in that case, it was for a news publisher who brought it forward. And it is important that we recognise it is creative industries in their broadest definition who are affected by this. And the newspaper publishers are particularly anxious about the consequences. And one of the amendments which Baroness Kidron tabled, which is now in the bill, emphasises the importance, and I know the Minister agrees with this, the importance of transparency. But it also requires that companies make clear, in meeting the transparency requirements, exactly what kind of activity the web crawlers are involved in. But because the newspaper publishers, they depend upon search, and it's very important that the search engines should be able to find and flag up their content, because without which they will not get the audiences they need. And that is a different exercise to that of training for ingestion and artificial AI created content. And so if we move to bring in legislation to require transparency, and the amendments now in the bill do seek to achieve that. I hope that is something that will be preserved, because it is very important that we have that transparency, not just as a general principle, but in detail in that way. Now, the Minister 2 weeks ago gave some very welcome assurance. He's done so again this afternoon. I think we need to continue to debate this. And as he says, if the government proceed, it will require legislation in due course, which obviously we will want to examine very carefully. The two things that are, again, I welcome. Firstly, there has been a view expressed on behalf of creative industries and the publishers that whilst the Minister and other members of government have been very open to discussions, the Secretary of State has not met them. So I was pleased to hear the assurance given by the Secretary of State earlier in this debate that he would meet the creative industries, because this is of such vital importance to them. And the other point which my honourable friend on the front bench raised is the lack of any economic impact assessment currently over the proposals within the consultation paper. And so I would hope that the government will produce an economic impact assessment. This is a subject which was not intended to be included in the data bill, although I welcome the fact that it is, but it is obviously one that we are going to be debating again many times. But I welcome perhaps outside committee as well, although I will rely on my colleagues who serve on the committee to carry out the work at that point as well. But I thank the Minister for his willingness to engage, and I can assure him we will continue to do so.